Hi, and we're back again. The second half of slides for the second week of human rights content in TRIB 2303. So we just left off at the end of slide 25, and we're just picking it up at slide 26, which is reconsideration and appeals. So reconsideration requests are available at the Human Rights Tribunal. A Form 20 must be filed within 30 days of the date of the decision. And the Form 20, which is the reconsideration request, must include reasons for the request, the basis upon which the request is made, and written submissions, and what remedy that the reconsideration application is seeking, okay? And responses are, of course, allowed to reconsiderations in a Form 21. A reconsideration will be granted by the tribunal in accordance with Rule 26.5. You can also find some reference to this in your textbook at page 43, so this is where reconsiderations would be granted, where there are new facts or evidence that could be determinative of the case and could not reasonably have been obtained earlier, where the party seeking reconsideration did not receive notice of the proceedings or hearing, which is obviously a concern with natural justice, the decision runs contrary to established case law, and is a matter of public importance. So if it runs contrary to established case law, that's essentially an error of law, right? Or if there are some other factors that the tribunal needs to take into consideration, which has reflected in an unfair hearing of some sort. And of course, judicial reviews are available to divisional court. So there's two other slides I wanted to mention to you, and two other thoughts. One of them comes from the case that's identified in the back few pages of this chapter in the textbook, which is the Human Rights Commission versus Simpson-Sears. It's an older case. It's a 1985 decision, and it actually comes from the Board of Inquiry, which was the predecessor to the Human Rights Tribunal in Ontario. Some of you might remember Simpson-Sears, right? The department store Simpson. So O'Malley was a full-time employee of Sears. She had converted to the Seventh-day Adventist faith, and required sundown on Friday to sundown on Saturday, free from work, so that she could take that as her Sabbath day. So her day of faith, her day of rest. So she notified the employer that she could no longer work during this time frame. Sears didn't accommodate her. They did offer her some part-time employment. So O'Malley complained to the Human Rights Commission, and the Human Rights Commission brought the case to the Board of Inquiry. The Board of Inquiry dismissed her complaint on the basis that it was not a case of intentional discrimination. This case eventually went up to the Supreme Court of Canada, and the Supreme Court of Canada found this to be a case of adverse effects discrimination. Okay, so it may not be intentional, but discrimination does not need to be intentional to be found discriminatory under the code, discriminatory behavior under the code. Adverse effects discrimination, and this is where we first see this case or this concept really balloon and go from here after that Supreme Court of Canada decision. The Supreme Court of Canada also found here that Sears did not accommodate O'Malley to the point of undue hardship. So that takes us into the next slide. What is undue hardship? And this is essentially the threshold that a respondent has to show that they met. They have to say, hold on a second, maybe you don't think I accommodated the employee or whoever the complainant might be, but in fact I did accommodate, and I accommodated to the point of undue hardship, and I can't accommodate any further because that is beyond undue hardship. So the code basically says individuals have to accommodate others to the point of undue hardship, but not more than that. If it's more than that, then they've met their onus or their requirement under the law to accommodate an individual. So it's not just an open-ended accommodation at all costs. It's to the point of undue hardship. Having said that, undue hardship is a very high threshold to meet. It's not easy for an employer to say, and I'm just using employer as an example because I think we see the employee-employer relationship come up a lot in these complaints or cases where there's alleged discrimination against an employee, perhaps on the grounds of disability, and then they claim that the employer did not accommodate them to the point of undue hardship. And the employer's response is, I did accommodate to the point of undue hardship, and I can't possibly accommodate any further. So what is that threshold, or where does that end? Well, the tribunal will consider costs, outside sources of funding, if any, to help an organization to accommodate, and health and safety concerns. And if there are significant costs or health and safety concerns or outside sources of funding that the respondent hasn't tapped into but could have to allow for the accommodation to happen, those are all going to play into whether or not they've accommodated unduly or more than necessary, okay, or at least to the point that they don't have to try to accommodate any further. They've done the most that they can. So I think I've given you an example in the past, perhaps in another class, but I've given you an example of if there's a sole proprietor who is trying to make changes to their small business storefront to allow for individuals in a wheelchair to access their store. Putting a cement ramp in would be reasonable. It would probably be unreasonable for them to say that they've accommodated to the point of undue hardship if they haven't taken steps such as that. But if a customer wanted to complain that there was not an elevator that allowed them to access to the whole unit or to the whole store, if it's a small sole proprietor and they don't have those, I guess just that big bank account to back them up and to allow for major renovations, it's possible that the tribunal might say, okay, this is to the point of undue hardship. We'll allow this store owner to have a ramp at the front, but we're not going to require them to conduct massive renovations to install an elevator, because that would eat too far into costs for them, and that could perhaps put them in the red, not the black, right, in a deficit space, because those renovations are just too costly for what this employer could bear. So that's an example of a sole proprietor, a small business owner, but that's not going to be the case when you have large businesses who have much more deep pockets and the ability to finance larger renovation projects to allow for an elevator, okay? So that's just one example of how perhaps the tribunal might say, you know what, undue hardship has been met here, and to force this small business to install an elevator, it might be beyond undue hardship because of the costs that are associated with it. So costs, health and safety matters, or outside sources of funding, if there are any that haven't been tapped into, these are all factors that the tribunal would consider in a respondent's argument, okay, that undue hardship has been met and it's now being exceeded. All right, I think that takes us to the end of the slides for the human rights stuff. I think it does, because the last few slides in there talk about your advocacy assignment. So if you're watching this video, you're probably in the week where your Human Rights Tribunal Advocacy Assignment Part A2 is due, which is the case law, and your opening statements, your closing statements, your direct and your cross with answers as well. I mentioned this in class, but I think for one of the sections it could have been very much so in passing because we hadn't launched into the human rights content face-to-face there yet. If you're looking for a case to rely upon in the area of our scenario, you are welcome to use a Board of Inquiry decision, which is the predecessor to the tribunal. I have warned you before about using old case law and sort of the factors or the checklist you have to run it through if you want to be sure that it's an appropriate case to use. But a lot of the area of our scenario in human rights law was decided upon by the Board of Inquiry. There's not as many recent cases on it by the Human Rights Tribunal, and so it would be appropriate to use a Board of Inquiry case for that reason, in addition to the fact that the code hasn't changed significantly between then and now with respect to the factors that you're looking for, the area of the law specifically, that niche area of the law that you're looking for human rights. So if you find a Board of Inquiry case, that would be completely appropriate. I would caution you about using outside jurisdiction cases, so cases that stem from a provincial tribunal from another province, because their law in this area could be vastly different from ours. The code might not look it, but the case law might look it. So I would urge you to stay within Ontario, from the Ontario Tribunal itself, or from an appeal court decision that's relevant to this area of the law that we're discussing. An older Board of Inquiry cases are entirely appropriate for this scenario. All right? Otherwise, that's all for me, guys, and we'll talk soon on a live class discussion. Take care. Have a great week.